Okay, good day, good morning, good afternoon, or good evening, class, depending on the time that you're going to watch this video recording this lecture. So before I start my discussion, I would like to share my screen with all of you to facilitate our better understanding of our topic for today. All right, there. Okay, so again, good day to all of you, and welcome to my lecture on the specific topic of the principles on jurisdiction of states. I suppose that all of you, before watching this video, have already gone through the course outline that I already provided to all of you, and not just the course outline, but also the annotation from the book of Father Joaquin Bernas. And also, when I say you have already gone through the course outline, I suppose that you have already read the different cases that I assigned you to read. No, my goal this day is to facilitate a better understanding of the different subtopics and the principles included in the general topic of jurisdiction of states. Okay, I know that when you read the book, as well as the different cases, the topic, all in all, I mean the cases and the annotations were a little bit overwhelming for all of you. That's why my goal for today is to endeavor to make the topic easier to grasp, to understand, and for you to be able to regurgitate the topic in such a manner that whenever you're confronted with this kind of topic in the future in the bar examinations, the topic or the question will not be daunting. So the topic no is very vast. It's encompassing different spheres and facets of international law, but I'm going to distill the topic to its barest essentials, and at the end of the session you will be able to get an easier no appreciation, a better appreciation of the topic. Okay, so when we talk about jurisdiction of states, we always have to go back to whenever I talk about jurisdiction of states, I always go back to a specific case, which is found also in our case outline, specifically under the topic of territory over land. And this case that I'm talking about is the case of Las Palmas case, or the island of Palmas. I hope that that specific case is still very much fresh in your minds. No, just considering that all of you uh, took the midterm exams a few weeks before. Okay, so in the many discussions under that case, the the arbitrator in the person of Swiss jurist Max Huber, he had the occasion to discuss the concept of sovereignty. And in there, he mentioned or defined sovereignty as the state's capacity to implement, to enforce within its territorial boundaries its sovereignty, to assert its right, to assert its power or authority over such specific land area to the exclusion of all other states. So that is that specific definition is a recognition of what in fact exists, or a general understanding of the customary nature of the concept of sovereignty. So mean to say that the sovereignty of a state over a certain territory is to be exercised by the state to the exclusion of all other states. And apart from that, no, apart from that definition, we have also encountered in other cases wherein the state, in the exercise of its sovereign capacity, has manifested no its sovereign right and sovereign power over a territory which is belonging to to its power, to its sole authority, no, or control. Okay, so there are different manifestations of this sovereign capacity. First one is the authority to enact laws or to introduce legislations within the territory. Okay? And the other one is, of course, since there are already legislations in place, the sovereignty of the state, no, also gives rise to the ability of the state to implement such legislation. And lastly, whenever the state is confronted with questions arising from the interpretation of the existing laws or enactments, the state, no, pursuant to its sovereign capacity, does have the right to interpret laws, whether in favor of one specific person, whether juridical or natural, or against another person. Okay? So there are three manifestations of the state sovereignty. Now, these manifestations of state sovereignty could be translated, no, to the principle of jurisdiction. Why? Because, no, when we talk about sovereignty, we also talk about, we could not separate, no, the concept of jurisdiction with the concept of sovereignty. Mean to say that the two of them are inextricably linked. Now, when the state implements a law, no, it is also an exercise of the state's jurisdiction, no, to implement the law. When the state enacts a law, it is also a manifestation, or it is also an exercise of the state's jurisdiction to, to legislate a law. And lastly, when we talk about the state's sovereignty, sovereign capacity to interpret the law, we're also talking about the jurisdiction of the state to interpret the law. Meaning to say the two cannot be separated, no, from each other. However, states, no, being subjects of international law, being animals, no, in the international plane, they cannot exist in isolation. And as subjects of international law, whatever sovereign rights that they have, a little portion of that is divested in favor of international law. So mean to say, while the state does have an absolute right to implement, to legislate, and to interpret laws within its country, this is to be qualified by existing principles under international law. Okay? And we've already touched upon that, the topic, no, the different qualifications. Why? Diba? During our topic on the relationship between international law and domestic law, we were able to discuss the concept of dualism. Diba? The concept of dualism mean to say that that international law and domestic law are different laws, no? Are different laws. However, however, in order that a state, no, in order that a state would not be held accountable internationally, its domestic laws, no, if we're talking about an international forum, no, the domestic laws of a certain state must comply with its obligations under international law. So mean to say that while the state does have an absolute sovereignty over its territory, it is nevertheless subject to certain exceptions. Okay? And these exceptions are embodied in the different principles which we're going to talk about today. All right? Okay, so there are different principles under international law when we talk about the jurisdiction of states. But take note, class, that of course, the most predominant and the widely accepted principle insofar as jurisdiction is concerned is always the principle of territoriality. Okay, so I mean to say that within the confines of a state's borders, of a state's territory, the state does have the right to do whatever that it wants to do, subject to certain exceptions, of course, under international law. So, for example, the state, of course, cannot make use of force, no, to the detriment of all other states or to the detriment of the entire legal community as a whole, no. And uh, the state's the state's authority and power over its territory may nevertheless be subjected as well to certain exceptions, and one of which is that aside from existing jus cogens norms, which we have already discussed during our prelims and our midterms, it is also subject, no, to certain treaties or agreements by the states. So, for example, one example, di ba? Within the Philippines territory, our military forces do have the absolute right, no, to implement to implement and to make sure that our national interests and our national security are upheld at all times. So whenever there is a military incursion or armed invasion by another state, our military forces do have the right to exercise credible deterrence and to repel whatever armed aggression is being posed by another state. So that's pursuant to the jurisdiction of the state, no, over our own territory. However, no, it may be subject to certain exceptions, and one of which is treaty making process or agreements entered into by our state. So one manifestation that would come into mind is that if you're talking about our military forces and our national security interest, no, is the Balikatan exercises. Diba? That's pursuant to to a string of international treaties and agreements entered into by the Philippines. So, diba, naturally, of course, whenever there's a presence of armed forces of another state within our territory, we can actually repel them if the transit or the passage of these armed forces appear to be prejudicial to our own state interest. But because of these treaty agreements, our absolute jurisdiction over our territory is watered down to a certain extent because we divest in favor of the other state, no, who is also a party to the treaty, certain rights to exercise or to send over military troops in our country. So when we talk about the agreements of the Philippines, no, pursuant to the pursuant to the strengthening of our military efforts, would come into mind are our mutual defense treaties, no, with the United States of America, and for a time as well, the for when the question of military bases was not yet, no, brought into the consideration of the Supreme Court of the Philippines, which merited a decision against the military bases. A portion of our territorial sovereignty or jurisdiction was given in favor of the Americans and its allies. Okay? Sige. Okay, so when we talk about the territoriality principle, it's very self-explanatory. So within our territory, within a state's territory, its sovereignty is absolute. Okay? Sige. So, the principle of territoriality is challenged or is modified by certain other principles, and some of which, to my understanding, have not yet reached the level of customary international law. But nevertheless, I'm going to introduce these principles for your understanding. Okay? So, many of these principles, no, have not yet been tested before an international tribunal as to its application. But what I'm pretty sure of is the principle of territoriality has already ascended into the level of customary international law. And up to a certain extent, the principle of universality, which we are going to talk about in full later on. But just take note of these different principles. Okay, let's go first to the principle of territoriality. So I've already discussed the principle of territoriality. No? Um, in the Philippine context, where can we find the principle of the territoriality principle? It could be found under Article 14 of the new Civil Code. While, of course, the new Civil Code is a civil law, it could nevertheless be applied in a suppletory manner to political law because it mentions a principle which is relating to public international law. It says there that anyone who lives or sojourns within the territory of the Philippines is subject to our penal laws or any other laws prohibited or considered as any other laws, no, governing certain conducts which are considered to be criminal or prohibited under our criminal laws, and of course subject to certain principles provided for under international law. So you mean to say, under Article 14 of the new Civil Code, the Philippines recognizes no the territoriality principle. However, the territoriality principle is not an absolute principle because our country recognizes that this principle is to be qualified by the principles or the rules of international law. However, di ba, we have to go back again to our to the concept of monism and dualism and the doctrine of incorporation, which is embodied under our constitution. So when Article 14 of the new Civil Code provides that our territorial jurisdiction is to be qualified by international law, what is meant by that is that international law is in the form of general principles of international law. So, mean to say, principles which are considered as customary in character, and not just any other principle which has not yet reached the level of customary international law. Okay, so when we talk about the territoriality principle, certain cases come into mind. And two of these cases are indicated in the course outline. And these are reflected in our slide right now. Okay, so the first one is the case involving SS Lotus. This is a case between France and Turkey. This case was adjudged by the Permanent Court of International Justice. So what happened in this particular case? No, over international waters or over the high seas, a collision happened between two ships. On the one hand, the ship, no, whose name is Court, and the other one whose name is SS Lotus. Now, Court flew the flag of Turkey, while SS Lotus flew the flag of France. So when the collision took place, of course, there was an allegation that the collision no transpired due to the negligence of the ship captain and the crew of SS Lotus. Now it was manned by a certain individual named Lieutenant Demons, Monsieur Demons. No? So after the collision, Buscourt suffered damages, and several sailors on board Buscourt died. As a result, Lieutenant Demons and the crew, no, together with the ship, no, they were brought into the jurisdiction of Turkey. So Turkey moored SS Lotus, and the ship captain, together with the crew, were detained for several days, for many days, in fact, no, until France was able to post bail, no, in favor of the ship captain and the crew. So consequently, criminal charges were brought against Lieutenant Demons before the local courts of Turkey, and he was found guilty for the deaths and the resulting damages on board Buzcourt. Now, France complained, no, that Turkey violated different one convention and existing customary rules concerning jurisdiction. First of which is the treaty or the convention, no, a certain convention which provided that Turkey does not have the jurisdiction to exercise, no, does not have jurisdiction to exercise its jurisdiction over such circumstance, no, the negligence, the alleged negligence of the ship captain of SS Lotus, and on the other hand, no, Turkey said, no, Turkey said that it does have the right of jurisdiction under international law because initially Turkey did not offer any legal arguments in opposition to the legal arguments of France. But eventually, no, part of its pleadings, Turkey raised the legal contention that there is no specific rule under international law which would preclude Turkey from exercising its jurisdiction over the ship captain of SS Lotus. Now, when the case reached the merit stage, the PCIJ ruled in favor of Turkey and against France. No, why do I say in favor of Turkey? Because the PCIJ, although the PCIJ recognized that France does have the jurisdiction to try Lieutenant Demons, such jurisdiction is concurrent in character. Mean to say that uh, if France is not able to exercise its jurisdiction first, Turkey does have the jurisdiction if it's able to obtain jurisdiction over the person of the crew members and the ship captain concerned. So here, in this specific case, the court had the occasion to discuss the concept of the effects doctrine. What is the effects doctrine? No, it basically says that a crime, no, which is a crime which takes place within a certain country's territory, no, takes place but is consummated in another country's territory, may be tried by the two countries involved. So the crime, no, was initiated within the territory of a state, but is consummated without or outside of the territory of the state or within the territory of another state. So that is basically what is espoused by the concept of effects doctrine or the objective territoriality principle. So in this particular case, in the SS Lotus case, the crime, no, was initiated within the territory of France because we have to remember that the ship is a natural extension of the territory of the state whose flag it flies. No? So it all started within the territory of France, but it was nonetheless consummated within the territory of Turkey, Buzcourt being an extension of Turkey's uh, territory. Okay? So at that particular point in time, the effects doctrine was considered as customary in character. However, take note, class, no, that this specific provision or this specific principle, the effects doctrine, specifically applied in the context of collisions at the high seas, has already been overturned, no, by the provisions of the UNCLOS. No, under the UNCLOS provisions, it says there that whenever there's a collision between two ships, no, while they are traversing in the high seas, at the high seas, no, it is the flag state or the state of registration or the state of registration of the alleged erring ship, no, or the nationality of the ship captain, whichever no state no is able to obtain jurisdiction over the person first, no, would have the natural and the legal right to exercise or to implement its jurisdiction over the erring persons. Okay? Sige. Another case, no, when we talk about the territoriality principle, is the trail smelter case. Now, this one involves the United States of America and Canada. There was the case was brought before an arbitration body constituting several persons, several judges. Now, the issue in this particular case involved the alleged damage brought about by as smelting a smelting company, Cominco, no, Cominco, which operated within the territory of Trail, British Columbia, in Canada. Now remember, no, that if you look at the geography, no, the Trail, British Columbia, is adjacent to the state of Washington of the United States of America. And allegedly, no, because of the operation of Cominco, its factories um, uh, introduced into the air lead and other noxious substances, which of course was carried no, from the territory of Canada into the territory of Washington, United States of America. And because of the smelting activities done in the factories in Trail, British Columbia, allegedly the productivity of the soil in Washington, in the areas involved, lower down, no, and there were notable damages incurred by the soil, by the trees and the crops in the area of the state of Washington, no. So United States of America, on behalf of the farmers and the people affected by Cominco's activities, no, filed a suit against Cominco, filed against a suit against Canada, no, for alleged visible and invisible damages. No, initially they struck a certain agreement wherein several articles were stipulated. It was initially stipulated under Article 1 of the agreement that Cominco was offering in favor of certain to the farmers the amount of 350 US dollars, no, but in the process, no, of the arbitration, the proceedings, eventually Cominco and Canada won because the case of the United States of America was handled by lawyers who were sloppy in the sense that they weren't able to properly frame the legal issues, no, instead of asserting the rights of the states to claim damages or invisible damages. They were only able to claim damages in the form of visible damages. So only those damages which took in the form of burns brought about or introduced no, to crops and trees within the state of Washington were considered as subject to indemnification. So from an amount of 350 US dollars, it was reduced to I think 70 something US dollars. And what is no, when we talk about the territoriality principle, the trail smelter case introduced different principles, which are not only talking about jurisdiction, but also talks about very important principles under international environmental law. But firstly, when we talk about the territoriality principle, we talk about the principle of sic utere tu ut alienum non leidas. Again, sic utere tu ut alienum non leidas. Mean to say, it means that the state the state is responsible for whatever damages incurred by another state if the injury or damage caused to the other state emanates from within the territory or jurisdiction of one state. It also provides that the state in the use of its territory must not cause damage or injury to another state. So this is a principle also finding application in our torts and damages subject. So it's already part of public international law as a manifestation of general principles of international law or GPIL. Okay, don't forget that. So a state must always make sure that activities within its territory must not bring about injury to another country's territory. That's why try to recall in our topic on law of treaties, we also have one topic wherein trail smelter arbitration, the principles introduced in the trail smelter also came into light. You remember the pulp mills case, di ba? The pulp mills were erected within the bank of the river at the side of Uruguay, and Argentina there made a complaint, because the activities in the pulp mills, had noxious effect not just within the side of Uruguay, but most importantly to the shared natural resource, which was the River Uruguay, and also on the side of Argentina. Okay? Sige. So here, it's also a reflection of the effects doctrine. Why? Because the alleged complaint act, the unlawful act, all started from the jurisdiction of one state, but the effects were felt in the territory of another state. Therefore, both states, pursuant to the SS Lotus case, both states do actually have concurrent jurisdiction to try whatever suits were to be brought about pursuant to the alleged injuries or damages sustained by the plaintiffs in this case. But since the case was initiated by the United States of America, United States of America opted to make use of arbitration proceedings instead of merely filing cases before the domestic courts of USA. Arbitration because, of course, if the case was brought within the domestic jurisdiction of United States of America, it would have elicited questions to be propounded by Canada as to the jurisdiction of the domestic courts. So arbitration was the best way to go at that time. Okay? Sige. We're done with the territoriality principle. Now, let's go to the nationality principle. Okay, so this is an exception to the general rule of the territoriality principle. So when we say nationality principle, the jurisdiction of over a person, whether the case may be criminal in nature or civil in nature, is to be determined not by the place where the crime or the conduct took place, but by the nationality of the offender. Take note, the nationality of the offender or the nationality of the defendant. Okay, so in the context of the Philippines, where can we find the nationality principle? If territoriality principle could be found pursuant to Article 14 of the new Civil Code, the nationality principle is found under Article 15, no, of the new Civil Code. It says there that laws, no, relating to persons, to the status, to the family rights, etc., of persons is to govern person where Filipino citizens wherever they may be. So mean to say that this specific article, Article 15, also has extraterritorial reach. So regardless of the current residence, the current place of work of the person outside of the country, the person is still subject to the Philippine laws and jurisdiction. Of course, only over certain exceptional circumstances. So, if we're talking about our civil laws, of course, diba, a person, a Filipino citizen who is abroad, um, may marry there, but of course, the person, no, the person who marries there abroad and seeks or obtains divorce outside of the country, or let's say the Filipino marries here in the Philippines and goes abroad and obtains a divorce decree pursuant to the laws of that country, the person cannot introduce no the divorce decree introduced by another state because the Filipino citizen has not acquired the nationality of the place where the divorce suit was instituted. That Filipino person is still subject to our civil laws, di ba? So I'm actually doing a review also of your civil law, no? Sige, anyway. So when we talk about nationality principle, two cases come into mind. The first one is the Blackmer versus US case, and the second one is the very interesting case of Notibom. So when we talk about the Blackmer versus US case, it talks about what is found no in the slide on the right in the right side of the slide, the Teapot Dome scandal. No, this was during the time of President Warren Harding of the United States of America, involving a cabinet official who was accused of bribery. No, so the cabinet official leased certain territories of the United States of America in favor of private corporations without going through the proper requisite of bidding. No, certain guidelines were not met. No, and there were allegations of bribery. Now, Harry Blackmer, is a U.S. citizen. However, he was already a resident of Paris, France. Now, he was called by the government of the United States of America to testify no, in the proceedings. So there were criminal proceedings brought against the cabinet official of the United States of America. So instead of complying no, with the the request, no, Blackmer disregarded the request. And consequently, a subpoena was issued by the courts of the United States of America addressed to Blackmer to testify in the case. However, Blackmer again no did not honor the subpoena. So he was held. So there were proceedings to hold him for contempt no, for disregarding court processes. Now, a case was because Blackmer was consequently cited for contempt, he questioned the decision, saying that the United States of America doesn't have the reach over him since he's already living outside of the United States of America. But the US Supreme Court in this specific case stated no, that if even if a person, even if its national is already living outside of the US territory, the United States of America still has jurisdiction over him, especially over matters requiring public interest. No, and in this particular case, since this involves a scandal, no, a scandal involving public funds, involving high-ranking officials, all the more that citizens may be compelled by the government acting through the courts to testify in favor of the government. So, according to the court, this did not violate the rights of the respondent, Blackmer, against security of his person, etc., etc., pursuant to the U.S. Constitution, U.S. Bill of Rights in particular. Okay? Sige. Another case involving nationality principle is the case of Nottebohm. No? Nottebohm is a German national. He's a German national. However, he from 1905 up until 1943, he lived, and put up businesses and owned several properties within the territory of Guatemala. Okay, take note of that. German national, but his properties and his residence was already transferred to Guatemala. Now, this was the case of Nottebohm, took place with World War II as the backdrop. So, Nottebohm, at that time, sensing that Guatemala was taking sides, in favor of the United States of America and its allies, and entered into the war against Germany. Nottebohm in I believe it was 1939, he obtained citizenship in a country, also within the European continent, and that country is a very, very small country of Liechtenstein. However you're going to pronounce it, Liechtenstein or Liechtenstein. Okay, so he obtained nationality. He underwent naturalization process pursuant to the laws of Liechtenstein. Now, eventually, he was granted the Liechtenstein nationality. Okay, so in 1943, at the height of the Second World War, um, Nottebohm wanted to go back to Guatemala. However, since he was earmarked as a German national, Guatemala did not recognize his Liechtenstein citizenship. And because he was already earmarked as an enemy of the state of Guatemala, the United States of America now froze all of his assets. And while Nottebohm was denied entry into the territory of Guatemala, he was extradited into the territory of the United States of America, and he was interned in camps until the end of the Second World War. So upon his release from the detention and custody of the United States of America, Liechtenstein instituted proceedings against Guatemala, for one, for denying entry in favor of Nottebohm, denying entry into the territory of Guatemala. And second one is for Guatemala's failure of recognizing the nationality of Nottebohm, which is now of Liechtenstein citizenship. Okay, but Guatemala, in its counter argument submitted before the ICJ, it insisted that the process of naturalization was suspicious, and it was it should not be afforded any stamp of approval by the ICJ, considering that the connection between Nottebohm and Liechtenstein at that time was tenuous. Mean to say, there was a clear and meaningful connection between the person and the country itself. Now, when the case was decided eventually by the ICJ, it ruled in favor of Guatemala. Why? Because the ICJ upheld the principle, the customary principle of effective nationality link, that for purposes of the exercise of diplomatic protection, it is not just the state of nationality, but it must be proved, by the state asserting diplomatic protection over a person, that there in fact exists effective nationality insofar as the state is concerned and the person over whom diplomatic protection is being exercised. Now, the ICJ introduced the effective nationality link. What is that? It says there that for purposes of diplomatic protection, it must be established by the state claiming a diplomatic protection that in fact there is a meaning that the person upon whom diplomatic protection is exercised, there is a meaningful connection between that state and the person concerned. And how is this meaningful connection established? There must be proof that the center of public interest of that person is devoted or is centered towards that particular state. There is a habitual residence. There is the presence of family ties, participation in public life, the what else? The inculcation of the values of that state, by that person, involving his children or family members. So these are just some of the indicia or indications, by which effective nationality link may be established. So in the case of Liechtenstein um, and Nottebohm, there wasn't any, because the acquisition of nationality by Liechtenstein nationality by Nottebohm was only out of convenience, and there wasn't any meaningful connection between the person and the state itself. Okay, and if you may have noticed as well, if you applied for, or if you've gone through laws about naturalization, many of the laws observed by different countries were sourced from this decision by the International Court of Justice. So before a person acquires the nationality of another state, by way of naturalization process, many of the guidelines as set forth in the Nottebohm case have to be observed. No, so I mean to say that the person has to be living within the state for a certain number of years. He has to have a meaningful connection with the state, etc., etc. Okay, sige. But again, if a case is brought before the ICJ, by a state espousing the claims of its nationals, no, still the state must be able to prove that effective nationality link does exist for purposes of exercising diplomatic protection. Okay, sige. Okay, let's now go to another exception to the general principle of the territoriality principle. And this time around, we're talking about the protective principle. The protective principle espouses the idea that it is the state whose national security or national interest are at stake, has the right to prosecute an offender, criminal offender, or a defendant in a civil suit. Again, protective principle could be espouses the idea that the state does have the jurisdiction over an offender or over a defendant involving suits, no, which concern the national security, the national interest of the state. Okay, so when we say protective principle, where can we find this one, no, this principle in the Philippine context, in our Philippine laws, to be specific? It is found under the revised penal code of the Philippines, the long arm doctrine, no? So wherever the crime may have been committed by any person, so long as the crime, no, has effects in our territory, no? For example, the introduction of fake bills and money, wherever the crime was consummated, no, if the money is introduced within the Philippine territory, no, that is subject to the long arm doctrine. So that is, no, a reflection of the protective principle. But when we talk about protective principle in the realm of international law, the most notable case or example is the case of the Attorney General of Israel versus Adolf Eichmann. So, if you are a history buff, no, Adolf Eichmann is one of the, well, the highest ranking leaders of the German Nazis, no, Third Reich, was responsible for the implementation of the rules against Jews, no, and for the killings of the Jews, no, which of course saw the demise of thousands upon thousands of innocent civilians. Now, in the aftermath of the Second World War, Adolf Eichmann fled and flew to Argentina, and he worked there as a factory worker. And he assumed the name of Clement, no, Clement. So he pretended to be an ordinary person, thinking and believing that he would be living the rest of his life, no, enjoying impunity. Okay, but without his knowledge, no, operatives of Mossad. Mossad is the intelligence security agency of Israel at that time. Were able to spot him, no, to locate his whereabouts, and he was abducted. He was abducted from Argentina and brought to the territory of Israel at that time. Now, initially, Argentina made a complaint, no, that what the Israel forces did was a violation of the sovereignty of Argentina. Why? Because again, we have to go back, diba, to the general principle of territoriality. It was a disrespect, no? It was a direct affront to the territorial jurisdiction of Argentina because Israel did not seek the approval, prior clearance from Argentina that the secret operatives of Israel would be abducting, would be arresting Adolf Eichmann. But eventually, the diplomatic row between the two countries was dropped, and the case was reduced into a legal battle before the courts of Israel. Okay, so when Adolf Eichmann, no, was brought to trial, there were several legal issues which were raised by his lawyer. Oh, first one is that the law upon which the trial was based, which was the 1950 Nazi and Nazi supporters law, no, the prosecution of Nazi and Nazi supporters law, um, it involves a law which runs in contravention with the principle of territoriality, which runs in contravention with the principle of nullum crimen sine lege and nulla pena sine lege. It also runs in contravention with the principle of ex post facto law, no? Ex post facto, and it also runs in contravention with the concept of sovereign immunity. Okay, so there were several defenses raised. However, the court of Israel did not give any legal fiat, no, to any of the arguments of the lawyers of Adolf Eichmann, um, primarily relying on the principle that we are talking about, protective principle, because what was at stake at that time, no, was the national security and the national interest of Israel. Firstly, on the matter concerning the territoriality principle and ex post facto, no, ex post facto, and the concept of nulla pena sine lege and nullum crimen sine lege. All three, according to the Supreme Court of Israel, no, have not yet ascended to a level of customary international law. No, so that was according to the Supreme Court of Israel. So meaning to say that the lawyers of Adolf Eichmann weren't able to prove that there were existing customs which would have precluded the courts of Israel to try Adolf Eichmann. And one of the reasons why the court of Israel, no, granted or recognized the jurisdiction of the court is that the courts, no, of Israel do have the right to prosecute and to punish Adolf Eichmann because of the nature of the crimes he committed. So there were allegations of acts of genocide, crimes against humanity, crimes against peace, no, etc., etc. And because of the nature of the crimes he committed, he is to be considered as um, hostis humanis generis, no? Mean to say that he is to be regarded as is an offender against humanity. No, so mean to say that the crimes that he perpetrated, no, are to be subjected to to the prosecution of all states which have interest, over the case. So in the case of Israel, no, since it had an interest at stake, no, the cases or the crimes having been perpetrated and committed against its citizens from all over Europe, no, the court of Israel said that Adolf Eichmann is to be prosecuted. Okay, and also as regards the acts of state, no, the court said that acts of genocide, crimes against humanity are not acts of the state. They are personal conducts of the persons involved, and in this particular case, Adolf Eichmann. So eventually, the courts found Adolf Eichmann guilty, and he was sentenced to suffer the penalty of death. So he was publicly executed by way of hanging. So right after he was executed, no, he was cremated, and his remains, no, were scattered in the Mediterranean Sea. So that is the case, no, the outcome of the case involving Adolf Eichmann. All right, sige. Moving along, the protective principle is somehow or more or less, no, also connected to this specific principle or the universality principle. This principle espouses the idea that a state, no, regardless of its connection with a specific offense, with a specific offender, or with a specific victim of the offense or the complaint act, such state does have the right to exercise jurisdiction if, no, if the crime that was committed or the act complained of is considered as a universally condemned offense. Okay, so what do we mean by universally condemned offense? So these are types of offenses which are considered by the international community as egregious in character, shocking to the senses. They are morally debasing. No? These types of conducts which are considered to be in violation of existing erga omnes obligations or existing jus cogens norm. And in fact, the ICJ and different tribunals have recognized certain conducts as in violation as violations of jus cogens norms and erga omnes obligations. So example, no, we have already discussed this one in our very first uh, uh, s- uh, class, no, very first session involving the Barcelona traction case. Although we only discussed, no, general principles of international law, but one portion there mentions several erga omnes obligations such as the obligation against aggression, genocide, racial discrimination, and slavery. So any act, no, which would fall under the umbrella of these four offenses are considered to be falling within the universality principle. So if a state now commits an act which is to be regarded as an act of genocide, any other state, no, any other state would have an interest to prosecute that person to the exclusion of all others. That's why the principle is termed universality, because jurisdiction is exercised in a universal manner. In principle, a state does have the right to prosecute that person regardless of the connection of that state, no, to the person or to the crime at bar. But of course, as a matter of convenience, as a matter of respect, no, the state would should give up its jurisdiction and give it in favor of the state that has a real and meaningful connection or interest in the prosecution and the punishment of the person responsible for a universally condemned offense. Okay, so I've already mentioned four. What else? Acts of torture, di ba? Torture, which is covered by many of the cases that I assigned you to read for today. No, acts of torture are considered as acts which are universally condemned. Torture, racial discrimination, slavery, and acts of aggression. Acts of aggression, we're going to discuss that in full when we reach state responsibility and use of force. Okay, so I already mentioned earlier, hostis humanis generis, or a person who is considered to be a criminal by the entire humanity. No. Okay, so some of the cases involving the universality principle are here. Now, Filartiga versus Peña Irala, Prosecutor versus Dragani College, US versus Alvarez McCain, and Kerr versus Illinois. Okay, first, Filartiga versus Peña Irala. So this involves Dolly Filartiga and Peña Irala. Okay, so Dolly Filartiga had a brother named Joelito, no, Filartiga, who was tortured and murdered by Paraguay police officers, no, and the head of the police officers was Peña Irala. Okay, so Joelito Filartiga was tortured and murdered, and based on their evidence, no, Joelito was murdered and tortured because of the activities of Dolly and Joelito's father, Dr. Jose Filartiga, who was an activist at that time in Paraguay. Okay, so Charges were brought against Peña Irala before the local courts of Paraguay. However, they did not see any light. In fact, the lawyer who was responsible for the filing of the charges was disbarred. So losing hope, no, Dali initially felt, no, that there was that she would not see justice at all within Paraguay. Now, by some turn of fate and the fortune, Dali and Peña Irala, no, were found themselves within the United States of America at a certain period of time, no? And Dali knew of the presence of Peña Irala. So she reported the matter to the immigration, and the immigration eventually, captured Peña Irala and was prepared to be deported out of the U.S. soil for overstaying. But before he was deported, Dolly Filartiga instituted a civil suit or damages against Peña Irala for the tortuous death of her brother Joelito. Now, at that time, no, the United States of America has, for one of its laws, the Alien Torture Act, no, or statute, and it basically says there that any person may institute a case, no, against another person for acts committed even outside of the U.S. soil, for acts which would fall under the concept of torture. So basically, the Alien Torture Act acknowledges that torture is a universally condemned offense in the United States of America, uh, as no as a bastion of peace and law and justice, no, wanted that persons responsible would not go off the hook, no, and would not walk the face of the earth with impunity. So therefore, pursuant to the Alien Torture Act, Dali was able to claim damages against Peña Irala. So here you can see a reflection of the application of the universality principle, that regardless of the place of commission of the Complaint Act, which is torture in this case, the United States of America nevertheless acquired jurisdiction and pursued a case, no, against or after the erring individual who is Peña Irala in this case. Okay? Sige. Another case, no, is the prosecutor versus Dragani College. This time around, this is the very first case that was instituted before the International Criminal Tribunal for the former Yugoslavia. So if you're already through with international humanitarian law, this case, no, and the whole structure of the ICTY is no longer alien, no, or foreign to you. So this was the very first case that was filed before the ICTY, but it took 5 years before this case, no, the wheels of justice started running, no, because at that time Dragan Nikolic was hiding. So it took several Serbian criminals, no, for him to be arrested, and eventually, from the possession and custody of the Serbian criminals, he was transferred to the custody and possession of the NATO-led forces, or the SFOR, at that time. So from the custody of the Serbian criminals, he was transferred into the possession and custody of Bosnia and Herzegovina for purposes of trial before the ICTY. Now, Dragan Nikolic, no, his lawyers, said that the prosecution before the ICTY could not be legally had because of the very precipitate means of obtaining jurisdiction over his person. Uh, the lawyer said that the only way moving forward is for the case to be dismissed, no, because while there is apparently jurisdiction over the rationale materiae or jurisdiction over the subject matter, there was no jurisdiction ratione personae, or jurisdiction over the person, over his person. However, no, in deciding over the this initial and preliminary a matter raised by the lawyers of Dragan Nikolic, the ICTY held that it does have jurisdiction over the case on the basis of the principle of male captus bene detentus, or that is a Latin term, no? Or in English, it means wrongfully captured but rightfully detained. Okay, again, wrongfully captured but rightfully detained. Why? What was the main consideration of the ICTY in holding such? No, the ICTY said that if the crime perpetrated, allegedly perpetrated by Dragan Nikolic were only common crimes, the court would have ruled in his favor. But the arrest, while precipitate, it may seem no abrupt or not following or extra legal, it may seem the crimes involved here, crimes against humanity and war crimes, no, are universally condemned offenses. Therefore, there must be a striking of balance between the interest of the international legal community, no, to hold him accountable and his basic legal rights. And in the balancing of interest, the court ruled in favor of the overarching interest of the international legal community to hold the person accountable. Okay? And also, it recognizes, no, it recognizes the idea that any state does have the right to assert rather its jurisdiction over his person regardless of the place of commission of the crime. So remember that that his crimes, no, were perpetrated within the territory of Serbia, no, the former Yugoslavia, but he was prosecuted and brought for proper trial, no, before Bosnia and Herzegovina. So it is a recognition of the universality principle. Okay, and this is also to be differentiated from the principle enunciated in the Adolf Eichmann case, no, wherein in that specific case, the court of Israel ruled that in matters involving the unlawfulness of the arrest, the accused may not raise such defense in order to strip the court of its jurisdiction. But in this specific case involving Dragan Nikolic, the ICTY said that such defense is a proper defense. It properly threshed out, and if properly, if it complies with the very strict guidelines of the ICTY, as I mentioned earlier, no, the balancing of the interest and the nature of the crime allegedly perpetrated. So it's a valid defense. So in the Philippine context, di ba, wrongful arrest or unlawful arrest, no, is a valid defense in criminal cases, which should be raised before arraignment. Okay? Sige. US versus Alvarez McCain and Kerr versus Illinois. These are two cases which were brought before the United States Supreme Court. US versus Alvarez McCain. I believe that this involves a certain doctor, no, a certain doctor. I think a certain doctor. I think Alvarez McCain. I'm not sure. Anyway, so a certain doctor who was abducted, from Mexico, correct, from Mexico to Texas, no, because this doctor allegedly was in cohorts with certain governmental law enforcement authorities in torturing and killing a certain person. And the allegation was that this doctor made sure that he was prolonging the life of that person. Okay, so that while prolonging the life of the person would suffer tremendously through acts of torture. Now, the jurisdiction of the court, the U.S. court, no, was questioned because of the unlawfulness of such conduct, the unlawfulness of the arrest. Nevertheless, the court said that the what do you call this? That the unlawfulness of the arrest, no, uh, is not a proper basis for the court to divest itself of its jurisdiction. So that was the ruling of the court, the Supreme Court. But it's a different matter if the trial court is concerned, no, in that particular case. Because initially, when the case was brought before the trial court, it was dismissed. So it was appealed to the Supreme Court, where the Supreme Court overturned the decision of the lower court, and the case was remanded to the lower court. But when the case was remanded, the accused in this case was acquitted, no, for lack of prima facie evidence. No, the case didn't even reach the jury stage, wherein the jury had to vote. No, so the case was dismissed. In Kerr versus Illinois, this time around, there was an operative, uh, 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 an agency, no, an agency operative which was granted by the United States of America an authority to arrest the accused in this case, no, the accused in this case for charges of larceny or theft. No, so the agent in this case was armed with extradition papers which were forged between the government of the United States of America and Peru at that time. So instead of implementing the arrest pursuant to the extradition papers, the agent, no, arrested unlawfully the accused in this case, no, and brought the accused to the jurisdiction of the United States of America. He arrested the accused, no, outside of the legal document that was given to him, because he was not properly assisted by the Peruvian authorities, because at that time there was a military takeover in Lima. No, there was a military occupation. There was an overthrowing of the government. So the accused here in this particular case questioned the jurisdiction of the U.S. court, but the court, through its Supreme Court, said that the case would nevertheless prosper, no, because of the nature of the crime, no, that was perpetrated by the accused in this particular case. However, no, take note that in both cases, instances, the U.S. versus Alvarez McCain and Kerr versus Illinois, there was an uproar. No, there was a backlash in the international legal community because apparently stamping approval or giving legal fiat to these extra legal means, no, would open the floodgates to unlawful abductions, which is, of course, no, would pose a very detrimental effect, no, to the security of persons, and which would be running repugnant to several international legal instruments and customs involving the protection of persons, in the security of their persons, and in the security of their homes. Okay? Sige. But that's how the US Supreme Court acted insofar as these two cases are concerned. Okay? Sige. And finally, no, the last principle, no, which is an exception to the general principle of the territoriality principle, is the passive personality principle. Okay, as you can see in your screen, that guy is named as Fawas Yunis. No, so he's the main subject of the case involving the passive personality. Okay, so the basis for the court's exercise of jurisdiction, if when we talk about the nationality principle, we talk about the nationality of the offender. It's the opposite in the case of passive personality. Why? Because the basis of the court's jurisdiction or the state's jurisdiction over a certain offense or over a certain person is the nationality of the victim, no? Victim of the offense or victim of the tortious act. So let's talk about the case of of United States versus Fawaz Yunis. Now that guy, Fawaz Yunis, was born in Lebanon, so he's a Lebanese, and he became a member of the Amal movement and eventually the Hamas. No, so um, at one instance, no, which became the basis of the case involving him, no, he led several persons in hijacking a certain airplane. It was a Royal Jordanian aircraft. So the airplane was sitting on the tarmac of Beirut, no, Beirut at that time, no, and the he and his men hijacked the airplane. Now they ordered the ship to land in Tunisia. So it's another Tunisia is the host country of the Arab Conference at that time. So he and his cohorts wanted to make a statement. However, they were not granted landing. No? So they had to refuel in Cyprus. No, but eventually, no, after several hours of negotiations, no, uh, Fawaz Yunis and his men allowed or landed, no, safely landed the ship and released the passengers. And the passengers, among the passengers in the airplane, were four American nationals. So take note. So all the rest of the 70 passengers were non-American nationals. Okay? Sige. So, although the ship, no, the airplane rather, safely landed at the airport, no, the passengers were released. The ship, the airplane rather, was exploded. So they destroyed, no, the Fawaz Yunis and his men destroyed the airplane. Okay. Eventually, no, eventually Fawaz Yunis, they weren't able to get whatever they demanded from United States of America and the Arab League members, Arab Conference members. So he made a public broadcast of himself, stating the purpose for the hijacking and made several demands. So after that, he was subjected to the issuance of a warrant of arrest by law enforcement authorities of the United States of America. Because at that time, or prior to the hijacking event, there was an amendment introduced to the Anti-Terrorism Act, no, the Crime Prevention Act of the United States of America, granting the United States of America in coordination with other states, no, granting the United States of America the right to prosecute individuals responsible for the commission of acts of terrorism, not just perpetrated within the soil, within the territory of the United States of America, but also overseas if the terrorist activity has for its victims American nationals. So the amendment, no, the amendment falls squarely to the facts of the case. Perfectly, there were four American nationals on board or aboard the Royal Jordanian aircraft, no, which was eventually destroyed, which was initially hijacked. No? So there was a warrant of arrest against Fawaz Yunis. And a few years after, through the cooperation of Cyprus, no, FBI officials posed as drug dealers, no? And while Fawzunis was aboard a certain yacht of the Mediterranean over the international waters, um, uh, off the coast of Cyprus, no, the secret operatives, the covert operation of FBI, no, they were able to capture Fawaz Yunis because of the alleged drug deal, No? So when Faustinius was captured, he was brought to the United States of America, and he was prosecuted there based on the passive personality principle and based on the Crime Prevention Act or the Anti-Terrorism Act, which was already amended by the United States of America. Now, initially, the lawyers of Aguas Unis questioned the jurisdiction of the court, saying that the U.S. courts do not have any jurisdiction because, well, for one, the Royal Jordanian flight, no, the specific airplane flies the flag of Jordan, no, and the crime took place in Lebanon, no. So there is no real and meaningful connection between the U.S. and the persons or the conduct in question. But the court proceeded to find him guilty, find Fawaz guilty based on the domestic law of the U.S. and based on the recognition of the passive personality principle. So eventually, Fawaz Yunis was found guilty and he was sentenced to suffer, I think, 30 years of imprisonment, until he was released. Okay, so by now you understand, the different principles again. So let's review. Territoriality principle, where the conduct in question happened. Nationality principle, the nationality of the offender or the defendant. We have the protective principle. No, the state does have jurisdiction over incidents or crimes involving state security and national interest. Fourth one is universality. Any state does have jurisdiction over the crime so long as the crime or the offense in question is considered as universally condemned. And finally, passive personality jurisdiction is based on the nationality of the victim. Okay, so I'm going to give you two scenarios for you to better get a good grasp, no, or understanding or an interplay of the different principles. All right? Sige. Okay, scenario number one. Okay, supposing, no, that the setting of our scenario is in Pentagon, so within the US soil. Pentagon is where all of the military intelligence, military decisions, military planning, no, of the US and its allies, no, some of its allies, but predominantly US, no, is being done. Okay, so there was a plan, no, hatched by terrorist individuals, no, to bomb Pentagon. Okay, so the plan, no, was hatched among several online hackers and bomb experts. And these online hackers were Russians, Chinese, and the bomb experts were Lebanese and Jordanians. So the plan was the online hackers would dismantle the security system of Pentagon so that the bomb experts would be able to infiltrate Pentagon and would plant the bombs, no, at very strategic places. Now, after the security system of Pentagon is down, as done by the online hackers, the online hackers, upon the signal of the experts who have already fled from the scene, the online hackers will remotely detonate the bombs and cause explosion. Okay, and such plan, no, came into fruition. The bombs were planted strategically. They were detonated remotely by the online hackers, and alas, no, there were several victims. No, as a consequence, victims were of British nationality, French nationality, and Nigeria nationality. Okay, so this is the scenario. All right. So applying different principles, no, under international law, if we're talking about the territoriality principle, who has jurisdiction? Obviously, it is the United States of America because the conduct happened within American soil. How about the nationality principle? It is Russia, China, Lebanon, and Jordan, which have the jurisdiction pursuant to the nationality, because the offenders, the criminals here, are its nationals. Okay? How about protective? Whose nationality, whose interest, national interest or national security is at stake? It is the United States of America. Why? Because clearly what the bomb experts and the online hackers did was a direct front against the military capability, no, and the political independence of the United States of America. So America, based on the protective principle. How about universality principle? Is it limited to the 7 countries here as found in the slides? As the slide? No, because based on the universality principle, any state does have the right to prosecute the erring or the criminals in this case. Okay? So any state that acquires jurisdiction over the persons of these criminals, no, would have the jurisdiction to try, because what they did, no, the act of terrorism is a universally condemned offense. Okay, finally, how about the passive personality principle? It is Great Britain, France, and Nigeria, the three of them, they do have the jurisdiction to try the criminals on the basis of the passive personality principle. But of course, no, they are subject to the laws, no, the laws of the 3 countries, whether they actually have the domestic laws, no, providing for such. Okay, sige. I hope it's understood, no. So we're going to have another example, a very obvious and a real life scenario. Okay? Sige. So you imagine, no, the 9/11 attack that was perpetrated against the United States of America. You were all probably very, very young at that time when this happened. Okay? So imagine, no, that an airplane was crashed against a commercial building, a commercial tower. No, so the airplane is of Australian registry, so it was registered flying the flag of Australia. And the hijackers responsible for the hijacking, no, and uh, for the use of the airplane in destroying the tower are Afghan nationals, Syrian nationals. Okay, and no, when the tower eventually crumbled, no, there's an embassy beside the tower, and such embassy, no, is owned by the People's Republic of China. So when uh, the tower, no, crushed into the ground, the embassy was also affected. So it was also damaged. The Let's say the entirety of the embassy was also destroyed. No, and the victims were Australians because they were on board aboard the airplane, Singaporeans because they were inside the airplane, Filipinos who were working in the Chinese embassy also died, and several US individuals also died as they were inside the Chinese embassy. Okay, territoriality principle. Who has the who has the jurisdiction? Obviously, no, based on our the SS Lotus, no, application effects doctrine, diba? It was initiated from the airplane, but the consummation was felt, no, in the building upon which the airplane was crashed into. Okay, so based on the territoriality principle, it is Australia, no? Australia, where the crime was initiated, the airplane, because it is an extension of Australia's territorial jurisdiction. And it is the United States of America that does have territorial jurisdiction because the impact or the effects of the crashing, no, was felt within the territorial soil of the United States of America. How about the nationality principle? It is Afghanistan and Syria, because the hijackers are its nationals, are their nationals rather. Okay, how about the protective principle? Apparently, it was breach, no, of the national security and interest of the United States of America, and it may also appear, no, that China would have could raise protective principle, because it might also appear, no, that the target was not just the tower owned by the United States of America, but also the embassy, which was juxtaposed to the tower. And finally, no, universality principle. So based on the universality principle, because this is clearly an act of terrorism, any state has an interest to prosecute the hijackers. But apparently, of course, let's say the hijackers were able to parachute themselves from the airplane. So clearly, any state would have the authority, would have the power to prosecute the Afghans and the Syrians in this case. And lastly, based on the passive personality, it is Australia, Singapore, Philippines, and the US. They have the right to prosecute the Syrian nationals responsible for the hijacking. Okay? See, I hope I'm clear. All right. Okay, so we are down to the last few topics, no, for today. Okay, let's go to extradition. Okay, so when we speak of extradition, it is a process, no, of a process wherein a certain person is removed from the jurisdiction of one state in favor of another state. Okay, so when we talk about jurisdiction, it is an act. No, when we talk about definition and the elements, it is an act of a state, no, of a state, by way of requesting another state, no, to give up the person, the custody or the possession of a person in favor of the requesting state for purposes of um, allowing the requesting state to investigate, to prosecute, or to render the full service of sentence, criminal sentence against the person subject to an extradition request. So, what are the elements of extradition? It is an exercise of the sovereign powers of the state. We have the mutual cooperation between the requested state and the requesting state, and the goal of which is for purposes of investigation, criminal investigation, criminal prosecution, and lastly, for service of sentence. Okay? Sige. So there are different modes or methods of specifying the grounds for the implementation of extradition. Now remember that there can be no extradition in the absence of a treaty or an agreement between states or among states in a multilateral convention or treaty. So there is no specific or a general obligation under customary international law to extradite a person, to extradite a person um, involving specific common crimes. No, because later on we're going to discuss in one of the cases today, no, that the obligation to extradite is customary involving certain cases. Okay, so what are the methods of specifying grounds for extradition? Okay, so states, no, when they enter into an agreement, may either opt for listing, specific listing, or double criminality. Okay, first listing. Um, Two countries enter into an extradition treaty. They list down all of the offenses which could be subject, no, of the request by the other state for purposes of extradition. So if a certain crime is not listed down as a subject of extradition, then the person who is requested to be extradited from one country to another country may not be extradited, because it otherwise it would violate the listing, no, the method of listing. The other one is double criminality. The double criminality is more expeditious, it's more convenient. Why? Because it says, no, it pursuant to this principle, so long as the crime, no, is considered, so long as the conduct is considered as a crime, na in the two countries, then any request for extradition may be granted, no, by the requested state, no, in favor of the requesting state. So usually it's the double criminality which is applied by states because it's more flexible in a sense. Why? Because of the ever evolving niche, no, or the body of laws, the penal laws, no, of the countries, because of course the list of penal statutes grow uh, year after year, so it's more convenient, no, for the states to opt for double criminality. Okay, but there are certain limitations to the exercise of extradition, and I've listed them down here. First one is discrimination. If the request for extradition is clearly for purposes of implementing discriminatory laws against one person because of the person's race, sex, gender, ethnic background, religious background, if that is the purpose of the extradition, then the request for extradition may be or should be denied because that the prohibition against discrimination is customary in character. Second one, political offense. No, for political offense, no, for a person may not be considered subject of extradition if what the person had done had committed is a political offense. And usually, whenever a political offense had been perpetrated by a person seeking asylum in another state, it is usually covered by the exception to the rules on extradition. Why? Because, well, the international law is working under the presumption that to grant an extradition request for offenses which are political in nature would run in contravention against the customary norm of the principle of non-refoulement or the principle of non-refoulement, that a person may not be expelled from the territory of a state if the person fears for himself or herself, that fears for her life or his life because of a political crime that he was committed or she committed back, no, in the territory of the requesting state. So um, be able to make a distinction. When we say political offense, it should be set apart from common crimes. So when we say political offense, for example, rebellion, di ba? Rebellion is a political offense. No? So if a person commits rebellion and seeks refuge in another country, the person who is the state rather requesting for the return or the extradition of the person responsible for instigating or implementing acts of rebellion, the requested state, no, may deny the request. uh, if you may be able to recall during our prelims, no, we discussed one of the cases involving this scenario, the asylum case involving Colombia and Peru. Okay, attentat. What is attentat? It is of Belgian origin. No, it is an exception to the political offense rule, political offense exception. So it's an exception to the exception. So whenever the head of the state, whenever the head of the government, or whenever the head of basta, so either the head of a state or the head of the government, no, is murdered or killed by a person or a group of persons, it could not be treated as a political offense. No, it's covered by the attentat clause. Now, if there is a request for extradition based on the killing of the head of the state or the head of the government, then such extradition request should be granted because of the attentat clause. It is an exception to the exception. Next, probable cause. A request for extradition should not be granted, no, if the request is not accompanied by sufficient evidence showing that the requesting state does have valid grounds to prosecute or to investigate a person. So if it appears, no, in the request for extradition by one state to another state that the request is not accompanied by clear and convincing evidence that the person sought to be extradited has committed a crime, then the request should be rejected. Okay, and lastly is the principle of specialty. The principle of specialty. Okay, let me just go over for a while. My calendar is acting up. Okay. Sige. So when we talk about the principle of speciality, it says here that a person, no, cannot be extradited for one ground if that ground is not covered by the request. Okay, what does it mean? So, for example, if the person is sought to be extradited for rape, once the extradition request is granted and the person is transferred, the person cannot be prosecuted for drug charges in the before the courts of the requesting state, because that is covered by the principle of specialty, not specialities, specialty. Okay, so the purpose and the actual implementation of such purpose must be in congruence. No? Otherwise, it would violate the principles on extradition. Okay. Okay, let's go to the specific examples of countries with or without existing extradition treaties with the Philippines. Okay, so if in the event that you happen to find yourself, no, having committed serious infractions against the against the Republic of the Philippines, there are actually certain states, no, whereby you could seek refuge. Of course, I'm not telling you this, no, to skirt around the law, but just for FYI, no, FYI lang, nothing illegal here. I don't I We should never condone illegalities, okay? But for academic discussions, examples of states wherein with which the Philippines has existing extradition treaties would be United States of America, United Kingdom, South Korea, Thailand, what else? Canada, Indonesia. So these are the countries where you cannot hide with impunity. But no, countries which do not have existing extradition treaties are as follows. So we have France, we have Iran, we have Saudi Arabia, we have United Arab Emirates, we have Brazil, Belgium, Venezuela, Israel, Vietnam, and what else? Austria. So these are just some of the examples of states, no, having extradition treaties with the Philippines and no extradition with the Philippines. Okay. Sige. So the basis, no, for extradition in the Philippines is Presidential Decree 1069 rather, which was implemented at the time of former President Ferdinand Marcos, the father, the senior, no? Okay. And one of the notable provisions there is that if a crime, no, has for its penalty lower than 1 year, then such crime is not subject to extradition. So for offenses which are petty, no, in character, they could not be subject to extradition. So the requirement is the threshold is 1 year at the minimum. Okay? Sige. I will not be going over the details of the two cases that I mentioned here. Secretary of Justice versus Honorable Lantion and the Government of Hong Kong versus Olalia. No, because I believe that these are cases no assigned in your constitutional law. But sige, just briefly, no, these are two cases, the arbiters of which do not jibe. Why? Because in the Secretary of Justice versus Lantion, no, this involved, I think, Mark Jimenez, no. There was an extradition request, no, filed by the United States of America to the DOJ of the Philippines asking for the extradition of Mark Jimenez. Mark Jimenez wrote the DOJ at that time, no, was spearheaded by former Senator Franklin Drilon. He made a request that he be furnished with the documents appended to the request for extradition. Now, the DOJ here, I think, if I remember it correctly, no, denied the request of Mark Jimenez on the ground that the extradition request now is still subject to investigation, subject to scrutiny by the DOJ, and there is the 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 person no, who is subject of the extradition here no, does not have the right to access the documents because for one, it's not a criminal proceeding. It is a proceeding which is sui generis in character. It's a special one. No, so he was denied. Eventually, Mark Jimenez filed a petition for certiorari, mandamus, no, uh, prohibition against the Secretary of Justice DOJ before the RTC, and the case reached the Supreme Court of the Philippines with the Secretary of Justice, no, the petitioner in this particular case. Now, what is prominent in this case is the nature of an extradition proceeding. So, in this particular case, there were several postulates which were introduced involving extradition. The first one is that the purpose of extradition is for the suppression of the crime. That's why there is the mutual cooperation between countries involved, the requesting and the requested. Second one is that the person, the extraditee, should be afforded uh, uh, should be afforded with the right to due process by the requested state. The third one is that the extradition proceeding is pursuant to the principle no, of pacta sunt servanda. So, I mean to say that states must comply in good faith with their obligations pursuant to the extradition treaty or agreement. Fourth one is that the accused no or the extraditee must not be a flight risk. There's no underlying flight risk. And lastly, which is no the subject of the overturning in the case of Hong Kong versus Olalia, under the Secretary of Justice versus Lantion, the Supreme Court said that the case extradition proceedings is sui generis in character, and that the accused or the prospective extraditee does not have the right to post bail because it's not a criminal case. It's not criminal in nature. Okay, so that's the SOJ versus Lantion. However, no, the five postulates no were modified by the Supreme Court in the subsequent case involving Hong Kong versus Olalia, whereby it retained the four initial postulates, but the last one was modified. No, the Supreme Court said that while the extradition proceedings are not criminal in nature. However, the mechanisms involved and implemented are akin to criminal proceedings. That's why the accused or the extraditee, the prospective uh, extraditee, should be afforded the right to post bail pending the petition for extradition. Okay? Sige. This one naman, ot didere ot judicare. This is a principle, no? An emerging customary international law norm involving universally condemned offenses. So this came into light, especially in the case of questions relating to obligation to prosecute or extradite between Belgium and Senegal, which was adjudged by the International Court of Justice. Now, um, ot dedere, ot judicare, no, when translated into English, means obligation to prosecute or obligation to extradite. So, mean to say that if the state decides not to prosecute a criminal, it has the obligation to extradite the person in favor of another state that is willing and that is able to prosecute such an individual. Now, this concept, this principle now was discussed in full in this particular case involving Belgium and Senegal. And the object, the person occupying the spotlight in this case was a former rebellion leader of Chad, Habre. Habre, he led a rebellion, thus leading to the ouster of the president of Chad, no? And while he was in power for 8 years, he perpetrated several crimes, some of which amounted to torture, war crimes, and crimes against humanity. So at the time when he was no longer in power, he sought political asylum before Senegal. No? So while he was in Senegal, certain complaints were filed against him to hold him accountable for the acts of torture, war crimes and crimes against humanity he perpetrated under his watch. Now, Senegal did not act on it, and act on the complaint. So separate cases were filed before Belgium because Belgium has a domestic law allowing for the institution of cases involving torture which were perpetrated in other jurisdictions. And that specific law is a recognition of the jus cogens character of the prohibition against acts of torture. And apart from that, Belgium, Senegal, and Chad were signatories to the Convention Against Torture. And it says there specifically under Article 6 and 7, the obligation on the part of states to initiate investigations involving conducts which amount to torture. And I think that is under Article 6. And under Article 7, it says there there is an explicit obligation on the part of states to prosecute individuals who are alleged to have committed acts of torture. So if the state does not decide to pursue investigations and prosecutions, the state has the obligation to extradite the person to other signatory states who are willing to prosecute the accused or the respondent concerned. Now, Senegal, of course, it sat idly by and did not act on the complaint, decided not to press charges, to initiate investigations against Habre, primarily because, obviously he was a former president of Chad. Senegal believed, that he is clothed with sovereign immunity, being a former head of state. And Belgium, acting on behalf of the Chad persons or Chad nationals who filed charges against Habre, instituted a case against Senegal before the ICJ. The legal standing, we're going to discuss that later on in the semester. But Belgium, among others, wanted to hold Senegal accountable based on Article 6 and Article 7. Article 6, Senegal, according to the ICJ, violated. Why? Because it did not bother to investigate uh, the complained acts of torture. No, when it came into its knowledge, no, that Habre perpetrated acts of torture, Senegal chose to look the other way. No? So there was a violation of Article 6 of the Convention Against Torture, according to the ICJ. And finally, in relation to our topic, the Otidere o Judicare, the ICJ said that Senegal was likewise in violation of this principle pursuant to Article 7 of the Convention Against Torture because since Senegal chose not to prosecute Habre, it had the obligation under international law, specifically under the Convention Against Torture, to extradite Habre in favor of Belgium or any other state, no, that was interested in holding Habre accountable. Okay? Again, finally, deportation. Deportation is to be distinguished from extradition in the sense that deportation is a unilateral conduct done by the state in order to expel a person whom the state feels is unwanted within its territory. So, for example, if the person has been overstaying in the country for for a longer period of time, no, if the person is undocumented, so that is a ground for deportation. Uh, what else? Also, deportation does not really require the existence of a treaty between two states. So it's a unilateral exercise of a state of its sovereign power over its territory. Okay? And, oh, there. The case involving Majoff versus Director of Prisons. So the setting of this one happened in the aftermath of the Second World War, involving Majoff, who is of Russian descent. He was a spy, Japanese spy from Beijing. He was brought to the Philippines, of course, to do acts of espionage. Now he was arrested. Eventually there was an order for him to be deported from the Philippines. Okay, so this specific case is based on the second petition for habeas corpus, no, because uh, Majoff was detained at the National Bilibid Prison of the Muntik, no, because at that time there wasn't any ship that was available to harbor Majoff and transport him back to wherever he rightfully belongs because Majoff was considered at the time as a stateless person. So this case is the case of a lonely guy named Majoff. No? So when the second petition for habeas corpus was filed before the Supreme Court said that the continuous detention of Majoff is a violation of his basic rights and fundamental freedoms, particularly his right to be not subjected to arbitrary detention. So the Supreme Court said that he should be released. No, but then again, he is a stateless person, so nobody really wanted to harbor him, no, as its national. Okay, so I guess that's it for our discussion for today. All right, let me just stop my share screen. No, all right. Okay, so for purposes of our quiz for today, we have two items. Okay, I'm going to uh, read the questions now. Okay, same drills. Okay, question number one, briefly discuss the different principles of jurisdiction under international law. Briefly discuss the different principles of jurisdiction under international law. And number two, distinguish extradition from deportation. Again, number two, distinguish extradition from deportation. Okay, so I'll be giving you until 12 noon of tomorrow to be able to submit your quiz for today's session. All right, so take care, all of you. and enjoy whatever is left of your weekend. Bye bye and God bless.